behalf of the people of the city of Roseville.
We have it here this afternoon, John.
This is a date and time set for a motion hearing to dismiss this parking ticket. Thank you, Your Honor. Here, sit down. Briefly give you a history of the facts. My client started his vehicle in his own driveway right outside the front of his house. He went back in very briefly to get his infant child ready for the cold. This happened back in January. And in that short period of time, he came out and there was a ticket on his car for leaving a vehicle running unattended. Now, our motion is pretty simple. It's that the ordinance which he's charged under does not apply to one's private driveway. And that is for a number of reasons. First, in the Court of Appeals case, People v. Rhea, it's been decided that your private driveway is not open or accessible to the public. And in the people's defense, the response to my motion, they say that clearly the issue of search and seizure, well, they start with clearly defendant goes to the extreme to argue that any other place could be a closed garage of a mechanic or some other type of private area where a vehicle is being stored. Clearly the issues of search and seizure apply to those circumstances, whereas the language herein protects against places that are generally open and accessible to the public and would likely permit an individual easily access a vehicle. Now, we agree with that. I mean, the people basically conceded that this ordinance only applies to areas open to the public, and according to People v. Rhea, your driveway, you cannot even get a DUI in your own driveway. So a driveway is not open to the public. The statute is not applicable to one's own private driveway. It is for streets and highways only, in other areas that are open to the public, boulevards, courts, avenues, that type of thing.
Where is People versus Rhea under brief?
I printed it out. It is not. I did not have it in my brief. I found it after.
Do you have a site for it?
Yes, I have a site for it. May I approach? Easy. Yeah, it's at the top part.
It's REA 315 Shaft 159.
What kind of case was that, counsel?
I was operating while intoxicated.
And they held that the driveway was not accessible to the public?
That is not. It is not open or accessible to the public, Your Honor. That is correct. They held that the Michigan Court of Appeals that a residential driveway was private property. They further went on that the upper portion of a defendant's private residential driveway does not constitute an area generally accessible to motor vehicles. And this guy was drunk in his car, running, and he never left his driveway. And they dismissed the case because it was not open to the public. And similarly, you can't. I mean, if you can't get a DUI, how do you get a parking ticket in your own private driveway?
I want to give you the head notes, counsel. Have you had a chance to review the case?
No, Your Honor. Actually, when he mentioned the case, the first thing I did was look for it in his brief. Didn't find it, so I've obviously not had an opportunity to review that case. It's very difficult for me to even try to attempt to distinguish it from the instant case due to the fact I haven't had the opportunity to review it, Your Honor.
Doesn't sound familiar to me, so I'm going to have to take that into consideration. Do you have any other argument this time?
Sure. Even without that case, the statute on its face says now he's being cited under Uniform Traffic Code Rule 458. So the person who has control or charge of a vehicle shall not allow a vehicle to stand unattended on any street or any other place without first stopping the engine. Okay. Now, in the same traffic code, Rule 211 states that provisions of this code that relate to the operation of vehicles refer exclusively to the operation of vehicles on streets or highways, except where a different place is specifically referred to.
Which it is, right?
No.
No?
There's no
Specific place.
no specific place is referred to. Any other place is wide open, is broad. And the word driveway actually appears in 3 other rules in there. The word private property appears in other rules. You know, the word sidewalks, all these specific places appear. So if the legislature intended it to apply to your private property or driveway, they would have stated so. And on top of that, also just a matter of statutory construction, that any other place, basically, it creates, if you're interpreting it as literally any other place, it creates a redundancy with the word street. Because basically the word street is redundant and completely unnecessary when you say any other place, because any other place would include streets. So any other place is actually a modifier of streets. So it's saying streets, you know, public roads, highways, avenues, boulevards, that type of thing, any other place. It's a modifier to streets. It's not meaning literally anywhere. And the people actually concede that point in the response, where it says defendant goes to the extreme by arguing that any other place could be a closed garage of a mechanic or some type of private area where vehicle is being stored. I don't think those examples are extreme at all. And it proves the point that it's, you know, basically, if this ordinance is read that you can't have your car running in your own driveway, valets would be illegal. They are unlawful. They leave cars running all the time. Mechanic shops. There's all sorts of examples where you might leave a car running for a minute and step away from it. And, you know, you can't do that on a street or a highway. That makes sense. Maybe not even like in a Walmart parking lot where it's private property but open to the public. That might not be okay. But in your own driveway, you are absolutely... This ordinance does not cover your own private driveway, and you can't even get a DUI in your driveway. It is clearly that this was meant for streets and highways, not your driveway. I think that's it, Your Honor.
Thank you, Your Honor. I'm going to try to organize my argument a little bit more succinctly when discussing this. I'll begin with the first issue of whether or not Rule 458 is limited to streets and highways only. I think the legislature and statutory principles of statutory construction are clear. If in fact the legislature or the authority adopting this rule did not want to include any other place, they would have limited it only to streets and highways. They chose not to, and in fact utilize a more expansive language. As the court's aware, under the rules of statutory construction, every word in the statute is to be given meaning, and in this case, any other place clearly identifies that it goes beyond just streets and highways, but any other place that a vehicle may be left unattended. The second argument that's been raised is whether or not there's a conflict between the 2 sections of the UTC. There's a conflict between Rule 211 and 458. As the court, I think, has recognized, the Rule 211 specifically provides that it refers only to streets or highways, except where a different place is specifically referred to in a rule of this code. The modification in Rule 458 is a specific modification. It's specifically referred to in that particular subsection. Again, applying the rules of statutory construction, the more specific governs over the more general, and it's our position that because 458 has been specifically modified to include any other place, the argument that it applies only to streets or highways as encompassed in Rule 211 is without merit. Your Honor, the last argument that the counselor has raised was with regard to preemption of the motor vehicle code by the UTC being preempted by the motor vehicle code. I've delineated my reasoning within my brief, even citing and quoting specifically the statutory directive by the Michigan State Police for municipalities to adopt not only the UTC by reference, but also the motor vehicle code, because there are some provisions that are covered under one where they're not covered in another. It does not result in there being a conflict in the statutory makeup upon which we relied and upon which the ticket was written. In fact, when this came out, this directive came out by the Michigan State Police, the City of Roseville did in fact shortly thereafter in November of 2014 amend its ordinance specifically to adopt both the UTC and the Michigan Motor Vehicle Code by reference. So we would argue that the preemption argument has no merit as well. All right, the last thing I want to talk about is counselor seems to think that there's no rational basis, a reasonable basis why this law exists. Your Honor, this law exists so that individuals who are nefarious and looking for an easy way to steal a vehicle are stopped or prohibited from doing so. Now, unfortunately, the owner of a vehicle becomes the one that ends up getting a civil infraction, so to protect everybody else from the ills of potential criminals. But we have repeatedly seen it in our city, other municipalities, where there are specific thieves who are looking for running vehicles that are left unintended. And they're not going into garages to take these vehicles. They're going into places that are open to the public or easily accessible. And this is a perfect example in this particular circumstance, where a vehicle was left wide open. The officer did his due diligence, made sure that the vehicle did not appear to be locked, and was running with the keys in it. Because obviously, if it's an automatic start, the statute's inapplicable. So the officer could have just as easily jumped in that car and taken it off with it. Less than 2 weeks after this incident in the city of Roseville alone, we had 2 thefts, identical in nature. People starting their car, leaving it unattended, and culprits taken off with their car. One leading into a high pursuit. And I think I also make reference in our brief about a tragedy that occurred in Roseville, where a woman did the same thing. Unfortunately, she left her 2 children in the car. She goes into the house, leaves the car running, and someone tries to take the car along with her children. She attempts to stop it and becomes seriously injured as a result of this offense. So, Your Honor, there is a important public safety goal that is trying to be achieved by having these type of regulations on the books. It wasn't just pulling it out of the air. There's a specific purpose, and that's to maintain the safety and integrity of all the residents who may be susceptible to someone trying to take a vehicle when they shouldn't have. And in this case, that's exactly what we're trying to avoid and what Officer Carey was doing during the conduct of his duties. We don't believe, from a legal standpoint, there's any basis for granting the motion to dismiss. I think the courts recognize that this People v. Reyes case that he's referring to, I have no idea what the facts and circumstances of that case. Haven't had the opportunity to review it. For all I know, it could have been the portion of the driveway where it was fenced in or blocks. I have no idea. I don't know what the response to that is, Your Honor. So if the court is going to potentially rely on that case, I would like the opportunity to review it as well as brief it in the event that's...
Well, I think we're both in that position in terms of what that case provides, so I have no problem. I think we'll take a short recess. I don't think we'll have to adjourn it again. I think we need to get it resolved today. But Mr. Sonberg, do you agree with the facts as Mr. Tomlinson stated on the record? Do you want to have testimony taken of the officer? When he says that the officer came to the property, saw the vehicle running in the driveway, and that he checked the locks, the door of the car to make sure that it was either locked or unlocked, and apparently determined the car was unlocked. That's when he wrote the ticket. Do you agree with those facts?
Yeah, we agree with those facts.
All right, then let's take a short recess, and we'll take a look at that case that Mr. Sonberg has cited, and we'll look at.
All rise. Court will take a short recess.
Yeah, go ahead. I'm going to go. Thanks.
Cell phones off unless you have authorization to use them. You do not as of yet. All rise. 39th District Court is back in session.
You may be seated. Did you have a chance to review that case, Mr.
I have, Your Honor.
Mr. Sonberg, before we get to that case, sir, I understand that you have an individual in this courtroom that has been streaming live on Facebook the proceedings. Is that correct?
That's correct.
Is there anyone that gave you that permission, sir?
No, I didn't realize that I needed
Oh, you did?
permission. I apologize
Did you
about
not
that.
know, sir, that you were an officer of the court?
I took it upon myself, Your Honor, and I...
No, I don't want to talk to you, sir. I'm asking the attorney. You knew that that was going on, right?
Yes.
Did you ask permission of the court?
No.
Did you know that you were a court officer, you were an officer of the court, sir?
Yes.
And why wouldn't you let me know that that was taking place?
I thought because it was already happening and we're in a
Oh,
public
really?
area.
This is not being live streamed, sir. Plus, they got permission from me to do what they're doing.
I apologize, Your Honor. It won't happen again. It's my
Really?
mistake.
I'm going to find you in contempt, sir. And we're going to set a contempt hearing for you. Before Judge Bodak, the Chief Judge Pro Tem. Sorry, for May the 18th.
You're going to be up north on the 18th for a case.
25th.
25th, it's fine. 8:15, you said?
No. Let's get back to the case. Mr. Tomlinson, you want to respond to the case?
I do, Your Honor. First, I want to bring to the court's attention that in fact, this is a decision that was issued in April of 2016. That matter is currently on appeal to the Supreme Court. They have requested supplemental briefs with regard to this particular case by the Supreme Court. So at this point, although the ruling stands, I think the court should be aware that it's being questioned by the Supreme Court and actually being reviewed. The more important thing, I think, Judge, is the facts are very specific in RIA. And I think from a legal standpoint, the court is making a determination based upon the specific facts of this case as well as the specific language of the OWI statute. First, with regard to the facts in RIA, it's a case of an individual actually backing his vehicle out of a garage approximately 20 feet. The court makes specific reference to the fact that it never passes the front of the home on the driveway, essentially not going beyond the fence line. So it is isolated in its focus of the vehicle being all the way near the garage and no further than the back of the house or the side of the house. It never goes beyond that point. In our case, the testimony would be that the vehicle was near the bottom of the driveway, approximately or less than 2 feet off the sidewalk, and was not adjacent to the side of the home in any way, shape, or form and beyond the fence line. The second issue, and more importantly, is the language that was relied upon by the court. In RIA, the court is focusing on the language of the OWI statute, which provides that essentially the operation of the motor vehicle must be in a place generally accessible to the public. And what's interesting is the court focused specifically on the word generally in determining that it was their opinion that the areas, the fact-specific area delineated in the RIA case would not be deemed to be, quote, generally, unquote, accessible to the public. Moreover, right in the opinion itself, Your Honor, beginning on, well, year 158, the court says, moreover, had the legislature wanted to criminalize driving while intoxicated in one's own driveway, it could have outlawed the operation of a motor vehicle in any place accessible to motor vehicles, omitting the adverb generally. But the statute uses the word generally to modify the word accessible, and the combined modifier to further describe other place. Judge, in our statute, we don't have the modifier of generally. It says any other place. Suffice it to say the RIA panel, if it would have been given our language, it would have found that any other place constituted the driveway. So we would submit that the reliance on RIA is misplaced and does not stand for the proposition that a driveway in its entirety or in its whole is not open to the public. So we would argue that that case is not dispositive of the case before the court.
Somebody?
Thank you. The facts and Ray of as far as the position of the car are actually very, very similar to ours. Our car was parked right up by the house, and it was certainly not past the sidewalk. It was at the top of the driveway. And as people say, this is good law right now. And people, Ray also held that physical ability is not the touchstone of general accessibility for purposes of the statute, providing that person shall not operate a motor vehicle on a highway or a place open to the public. So this is saying that your driveway as private property, it doesn't need a fence. The pictures of this show it's a wide open driveway, just like
The
my
court
clients.
talks about it being like in the backyard or the side yard of the defendant. So distinguish that from what you have.
In Rhea? In Rhea, the guy drove backwards out of his garage and stopped before the sidewalk. Okay.
He was still in his side yard or rear yard. That's what the case law specifically
Well,
talked about that.
Even in our case, the car was right up, you could say, on the side of the house with the front. It's like a Roseville house has like a little porch and the garage in the back, right up there on the side.
We got an officer shaking his head, so it looks like we're going to need some testimony. Officer, would you raise your right hand, please? You
Yes,
solemnly
Your
swear affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, Your Honor.
Have a seat, officer. Would you state your name for the record, please?
Officer Kevin Carey, badge number 282 of the Roseville Police Department,
Go ahead.
Thank you, officer. How long have you been with the Roseville Police Department?
4 years, sir.
And were you on duty on January 5th, 2017 at approximately 12 o'clock p.m. on that date?
Yes, sir.
And what were you doing?
Conducting traffic enforcement throughout the entire city.
Did you have reason to have your attention drawn to a vehicle located at 26815 Waldorf?
I did.
And what drew your attention to this vehicle?
Exhaust coming from the exhaust pipe, and at first glance, I saw nobody inside the vehicle or around the vehicle.
All right, did you stop at that point?
I did. I stopped my patrol vehicle directly in front of the home. Once again, I did not see anybody in the car, did not see anybody looking out a window or a door. No one was anywhere in the yard. I proceeded to go check the vehicle. I looked inside of it. It looked like all the doors were unlocked. I could definitely see keys in the ignition. I looked around the car one more time, walked back to my patrol vehicle, began checking in the law enforcement information network to find out who the registered owner was.
And did you find the registered owner?
Yes,
And who was the registered owner?
Taylor Trupiano.
Okay. And that's the defendant that's to my left on the purple?
Correct.
And officer, can you describe to the court, there's been a representation by defense counsel that the vehicle was parked on the side of the home or near the side of the home. Can you describe to me exactly where it was in relation to the relationship to the home and the actual sidewalk?
The rear bumper of the vehicle was no more than 3 foot away from the sidewalk.
All right. And then what about the front bumper? What was its relationship to the home?
However long the vehicle is, it would still be shy of the front porch of the home.
All
It was
right.
clearly not in the side of the home. It was in the front part of the driveway.
Now, you know what's commonly referred to as like a fence line or the front of a home, correct?
Yes, sir.
Was the car or any portion thereof beyond the front line to the rear of the home?
No, it was not.
Approximately how long did it take, did finally the operator of the vehicle come out of the home?
Nobody ever paid any attention to the vehicle. I was, from the time I stopped the car to the time that I drove away, I'm estimating to be between 10 and 12 minutes. And in that time, there was no one taking care to protect that vehicle. Nobody came to check on it. Nobody came to inquire why a police vehicle was parked in front of their home.
Did you have your lights on?
No, you would only have your lights on if you're trying to get someone's attention to stop a vehicle
Fair,
moving road.
fair enough. I have no further questions. And this happened in the city of Roseville, correct?
Yes, sir.
I have no further questions, Your Honor.
Somebody, you want to press again?
Sure. So you seen the video, when you seen the vehicle, it never crossed the sidewalk like over towards the street side, correct?
I never said it crossed the sidewalk.
Correct.
I said it was close to the sidewalk.
Okay, but not on the sidewalk?
No.
And then the front was actually near like their front porch area. Is that correct?
Correct.
And you walked up to the vehicle and put the ticket under the windshield wiper?
Correct.
And about at that moment, so at the front of the car, how close were you to the home itself?
To the home itself,
Yeah, or the porch?
20 feet.
20 feet?
I'm on the driver's side of the vehicle. The home is on the passenger side of the vehicle.
And you're saying you're 20 feet from the house where that car was parked?
From where I stood, if I wanted to reach the front porch, I would take approximately 20 steps.
Okay. So to get a picture, so this driveway's up along the house, right? It runs along the left side of the house if you're facing it. Is that correct?
Correct.
So if you step 20 feet off the porch, you'd be in the neighbor's yard, wouldn't you?
Well, you're saying, how would I get to the porch? Are you saying from linear foot, standing here, standing straight forward?
I'm saying from that front of the car, if you walked to the house, I'm not talking any sort of strange path, if you just walked right to the house, how close is that car to the
That would
house?
probably be about between 5 to 7 feet.
5 to 7 feet. Okay, so it's parked next to the car, running, or I'm sorry, it was parked next to the house, it was running.
It's
That's
parked
your
in front
testimony.
of the house, in my opinion.
In
The driveways would fit long enough that if somebody wanted to take the extra care to pull it past the fence and pull it back towards the rear of the yard, they could easily do so.
So there was a fence?
I don't recall if there was a fence or not.
You said that if someone took the time to pull it
I
back.
said, in a driveway like that, that driveway is long enough that someone could pull the vehicle and it would be on the side of the house or possibly behind the house.
So the car was like in line with the house? Does that make sense?
It was not. It was more towards the sidewalk than it was towards being on the side of the house.
Right, but it's on facing the house. It's on the left in the driveway.
Yes.
And the driveway's to the left of the house. The driveway's not in the center of the house. It's to the left.
Correct.
Correct. Okay. And how long were you there for? How long did you observe the car run?
Approximately 10 to 12 minutes
10 to 12
is
minutes.
what usually a time frame for me to pull up,
Okay.
observe the vehicle, go back to my vehicle.
And to your knowledge, this is so to prevent.
This is a public safety issue, plain and simple.
Okay. And did you ever knock on the door?
The registered owner is not registered to any house over there. He's registered to 14837 Heather Point Drive.
But it's a public safety issue. But you never just
Well, for all I know, it could be someone living in another house. Maybe that house is vacant.
So you did not knock on the door.
No.
You didn't attempt to like let anybody in that house know, hey, this is a dangerous situation. Somebody might steal your car. You didn't. You just left the ticket and left the car still running, right?
I drove down to the end of the street.
So the car was the same as when you got there as when you left. All you
Correct.
did was leave the ticket, correct?
Correct.
Okay. Okay. I have nothing further.
Mr. Thomas, anything further?
You indicated you pulled down to the edge of the street. What did you do there?
I sat down at the end of the street, checking my list of what we call BOLs. In that area, there's several streets that routinely are, we are receiving complaints for people speeding, not obeying stop and yield signs. So at that point, that was my whole point of going to that area that day was, I believe I was checking on several different streets in that area. So at that point, I was checking my notes to determine where I wanted to sit next.
No? I have no further questions, Your Honor.
Anything further?
You didn't take any pictures of where the car was parked,
No.
and your video camera wouldn't have caught it.
Video camera gets turned on when I interact with a person. If I would have interacted with someone at the home or near the vehicle, the video camera would have been turned on.
Okay. Do you wear a body camera?
No, we do not have them.
Okay, nothing further, Your Honor.
Any further, Mr. Thompson?
No, Your Honor.
All right, any further argument, gentlemen?
Yes. So, People v. Rhea. In that case, the defendant drove his car from his garage to a point in his private driveway in line with the house. Residential driveway was private property. This whole argument of it being the side or the back or whatever, that's completely irrelevant. Your driveway, according to People v. Rhea, is not open to the public. It is.
Well, it talks about the accessibility of the driveway. I think that's, when they talk about general accessibility, that's what they're talking about, whether or not that part of the driveway would be generally accessible. In fact, they went to great lengths in that case to talk about the fact that a very small, they talked about a small number of the people of the universe would be entitled to be in that area, which is kind of a stretch to me, but.
Well, but it's not.
It's obviously a place that is more private in nature than what we have here. We agree with that.
Well, private property is certainly, and the court even says that's why they include pictures of the house in the case. They even say you don't need a fence, you don't need anything. Your driveway is not open to the public. That's the whole.
They didn't say that. They said that part of the driveway is not open to the public. They didn't say that not all part of the driveway
Sure.
is not open to the public.
And in this case, the defendant drove down and didn't cross the sidewalk. Similarly, my client, per the officer's testimony, never crossed that sidewalk line to be on the other side. So basically, his location is fine, and his location is not open to the public.
Well, the case talks about the fact that they would not be in contact or potential contact with non-trespassing members of the public, which would be somebody walking down the sidewalk. So if that case had been decided with the facts of this case, that was Mr. Trupiano, obviously he was not driving, but he had been in a vehicle drinking the way that this individual had in Rhea, which is what you're trying to tell me is the same law, then where he was positioned, he would have been in an area that would have been accessible to the public.
No.
Absolutely, sir.
You
never drove into a driveway and backed out of it?
I understand that, Your Honor, but the court says that it's not, even though you can physically do that, it's not, for legal purposes, considered open to the public. And that's what the case is about.
Beg to differ. Anything else?
Well,
Go ahead, when you're
okay.
done, I'll finish.
Well, besides People v. Rhea, the statute itself, on its face, the plain reading of the statute, it's not applicable to private driveways or even private property in general. It says street. The modifier of any other place, it's modifying streets. Okay. The people brought up that you read here that they must give effect, that the courts must give effect to every word, phrase, and clause in a statute, and avoid an interpretation which would render any part of the statute surplusage or nugatory. Okay. So if you say street or any other place, well, you can't read it as any other place meaning anywhere, because that would include streets. So it means that word is surplusage. It's nugatory. That word wouldn't even matter. So what any other place is actually doing is modifying streets. It's saying streets, boulevards, avenues, anywhere like that. And the other city ordinance of 211 says that, hey, unless another place, a different place is specifically referred to, that this code refers exclusively to streets or highways, unless another place is specifically referred to. And driveways are referred to in other codes, and private property is referred to. But any other place is a modifier of streets. It is not a literal anywhere. It doesn't mean literally anywhere.
Judge, even setting aside the whole factual dispute of where the vehicle was located, where it wasn't located, what the Court of Appeals really meant, I think we still turn on what the language of the statute said. And they're focusing on the definition of generally, quote, generally accessible. And from a pure legal standpoint, the court said, well, if they didn't include generally in there, then we're talking about a different issue here. But once they used the modifier of generally accessible to the public, it changed the game, because their whole analysis turns on their interpretation and application of generally. We don't have that here, Judge. It doesn't say generally any other place open to the public. It says any other place. So we would submit that the RIA case is completely inapplicable, and moreover, it definitely doesn't hold for the premise that your driveway is a complete private location and not accessible to the public. It turns completely on the word.
Any other argument?
Yeah.
No, Your Honor, I am done.
No, and we are past REA, and that's what I was saying in my last argument, that REA aside, the statute still does not apply to your driveway, based on the previous argument I gave. And even in the people's reply on page 5, they say, in lieu of specifically setting forth driveways, parking lots, and other specific locations where a vehicle may be parked to ensure that everything was covered, the vehicle is left running unattended, could lead to a dangerous situation. They say, in lieu of specifically setting forth driveways. No, there is no in lieu of. The statute says that a different place must be specifically referred to, and it's not. So there is no in lieu of. If they wanted it to apply to anywhere other than roads and highways, they would have specifically said. Just like it did in other statutes. They refer to sidewalks and driveways and all these other places.
All right, the court's had a chance to review the briefs that have been supplied to the court by both the prosecution and the defense. Obviously, this is a case involving a parking ticket that was issued by Officer Carey. Officer Carey approached the property and determined that the vehicle that was running was unattended. He checked to make sure that the car was unlocked, and it was unlocked. The Uniform Traffic Code refers to the fact that a person who has control or charge of a motor vehicle shall not allow the vehicle to stand unattended on any street or any other place without first stopping the engine, locking the ignition, and removing and taking possession of the ignition key. The provisions of this rule that pertain to the locking of the ignition and removing and taking possession of the ignition key do not apply to motor vehicles that are manufactured with an ignition system that does not have a key and that is incapable of being locked. So, obviously, there's a situation with the newer cars that can be started remotely, or any vehicle that can have remote starting can be started remotely. This particular code does not apply to, the rule does not apply to. However, we have a situation here where we've had, as security, I don't think he testified to it, but as Mr. Thomason was alluding to, we've had several situations where vehicles have been stolen, where vehicles were in the process of being stolen, and individuals were hurt as a result of that. Certainly there's a good reason for that rule. I think it's, in this case, it's applicable. I think that the vehicle that was positioned in Mr. Trujillo's driveway was in a place where it was generally accessible to the public. And frankly, that's what I feel is legitimate as part of that rule. When we talk about any other place, I think we can split the field on that issue, but I think that as long as it's generally accessible to the public, I'm satisfied. This was generally accessible to the public because it's a driveway that anybody could, the short driveways that we have in the city of Roseville where people can drive in, back out, and it's accessible to the public. In that area where Mr. Trujillo's vehicle was. So based upon that, I think it was reasonable that the officer issued a ticket and denied the motion by the defendant. I believe Mr. Trujillo has already paid the ticket. As part of a bond that was set for today's hearing. So that money may be applied.
Did you give money to the court to post a bond? You did? To someone?
I think so.
Someone else.
The case is ready, Mike?
Thank you, Your Honor.
All rise. 39th District Court will be in recess.
So since he hasn't, we have 21 days to appeal, so it's right?
I don't know what the timeline is, I'd have to find out.
I didn't know if it was paid or not, if that.
Well, yeah, he made the rule that, yeah, he closed the case and applied the bond to the department. So,